Hi, everyone, and welcome to the SRHM podcast, which explores new research and emerging trends in the field of sexual and reproductive health and rights, with a focus on using rights-based knowledge for action.
Hello, good morning, good afternoon, good evening. I'm Eszter Kismodi, Chief Executive of Sexual and Reproductive Health Matters, and welcome to the SRHM podcast. Today's episode focuses on a recent Court of Appeal decision in Kenya that has raised significant concern among human rights advocates, both in Kenya, in Africa, and around the world, among healthcare providers and reproductive justice movements, again, both within Kenya and the ruling overturned an earlier landmark High Court decision related to abortion and post-abortion care and reinstated criminal proceedings against a young woman and a healthcare provider after she sought emergency medical care following pregnancy complications. While this is a legal case, it is also about much more than the law. It raises broader questions about politics, power, gender inequality, and who gets to exercise control over bodies, healthcare, and reproductive decision making. I really warmly welcome our guests today. Martin Onyango, Associate Director for Legal Strategies at the Center for Reproductive Rights in Kenya. Hello, Martin.
Hi, thank you, listeners. It's a pleasure joining you in this call.
Ruth Mumbi, Human Rights Defender and Executive Director of Women Collective Kenya. Hello, Mumbi.
Hi, Kismodi. Good to join you this afternoon.
And Nelly, Munyasia, Executive Director of Reproductive Health Network Kenya. Hello, Nelly. Thank you for being here.
Hello, Kismodi, and happy to be part of this podcast. Thank you.
So I think we are ready to start the conversation, and we will together unpack what the court actually decided, what the Kenyan legal framework says about abortion and post-abortion care based on this decision and by law, and what this ruling means for women, girls, healthcare provider, those who get pregnant, and health system more broadly. We will also explore how criminal law, stigma, misinformation, and public narrative shape the lives of women and girls, particularly those already facing social and economic marginalization, and also discuss how media advocacy and rights-based approaches can help reframe abortion and post-abortion care in a just and human rights framework. So I'm turning to you, Martin, first, and you served as a lead counsel in this appeal. Could you briefly explain the background of this case, who the key actors and parties involved, and what the Court of Appeal ultimately decided?
Thank you, Kismodi.
Over to you, Martin.
The case that was decided on the 24th of April came from a decision of the High Court. And briefly, what took the petitioners before the High Court? One, the petitioner was a young girl who was 17 years old. She became pregnant, lost her pregnancy, and sought emergency care from a clinical officer, a trained health professional. When she went to the facility and the clinical officer made a determination she had lost the pregnancy, he quickly embarked on post-abortion care process and thereafter admitted the patient to recuperate. At this point, the facility was raided by the policemen. The girl was arrested from her hospital bed, taken to a police station. The provider was equally arrested. They were taken to a police station. The girl was then subjected to forced medical examination in a public health hospital with the intention of using that examination to charge her. They were then both charged with the offense of abortion, offenses related to abortion. Remember, the girl had sought post-abortion care, but they were charged with an offense related to abortion. Under the circumstances in Kenyan law, a child who becomes pregnant is entitled in law to safe abortion as a remedy for sexual violence. That is already the position in law. The Constitution of Kenya equally protects access to abortion in emergency situations or if a woman is in danger or when allowed by any other written law, like the sexual offenses law. So when they were now charged with offenses related to abortion, yet the service was a post-abortion care, we objected before the magistrate's court, saying that these charges are unlawful because the law already permits even abortion under those circumstances. The magistrate did not agree, recommending that we can only raise that challenge at the point of defense when the prosecutor has closed his case. So we said the treatment the girl had undergone, the question around whether the charges themselves are lawful should then now be handled by the High Court, because we were now seeing the rights of the provider, the rights of the girl had been violated in the process, whether it is their right to health, dignity, freedom from cruel treatment similar to that, and also just the fact that the girl qualified even for safe abortion in law. And so we moved to the High Court. The High Court agreed that one, it was wrong to arrest a patient from a hospital and take her to a police station to charge her with an offense. Two, it was wrong to charge her with an offense of abortion if she already qualifies in law for abortion as required by the Kenyan law and the Constitution. And therefore, the High Court, one, stopped their trial, two, declared that the treatment they had undergone violated their rights, including the right to health, dignity, privacy, and to be free from cruel treatment. The High Court then ordered that one, the parliament should then enact a clear law on when abortion is lawfully available in Kenya. The High Court also declared that healthcare providers providing care within the law must not be subjected to any criminal prosecution. The court also ordered that communication between a healthcare professional and the patient is protected under the Constitution and the law, and therefore cannot be violated and used to charge any provider or patient with the crime of abortion or any other crime. But the court went further to pronounce itself on one, abortion being a fundamental right as captured in the Constitution. And so that was the celebration we had in 2022, building on a previous decision again by the High Court of Kenya. When that decision came out, some people were not happy. An anti-rights group called Kenya Christian Professionals Forum and its allies moved the Court of Appeal and diverted the conversation from the treatment of the girl and the provider to a conversation or a campaign around ideological campaign against abortion, which was totally not the issue before the High Court. And now they sought to challenge the High Court decision, basically following the steps of anti-abortion campaigners. When they moved the Court of Appeal, the government side also realized that they should not be left out. They also moved the Court of Appeal on a second appeal, now disagreeing with the entire finding of the High Court. So there were two appeals. The Court of Appeal consolidated these two appeals into one, but the Court of Appeal, one, did not address the finding of the High Court that the treatment the young girl and the provider were subjected to violated their rights. And because of that violation, that is the reason why the High Court stopped their prosecution. But the Court of Appeal went into the conversation raised at the appellate level by the anti-rights group, the conversation as to whether abortion is a fundamental right. And the court made pronouncements that were then now contradicting the finding of the High Court, pronouncing itself that abortion is not a fundamental right, but still recognizing that the Constitution of Kenya allows abortion under certain circumstances. The worst part of the decision of the Court of Appeal was to say that the provider and the young girl, having been declared free from any prosecution in 2022, should now go back for trial in 2026. And that was the worst part of the decision. And now, because of the confusion that has existed or has arisen out of this decision, there are a few things that are necessary to clarify. That one, the law on abortion in Kenya was never in challenge, either before the High Court or before the Court of Appeal. So that law remains solid. The Constitution still protects abortion. The Sexual Offences Act still protects access to abortion for survivors of sexual violence. The Health Act still recognizes abortion as a fundamental right and recognizes trained health professionals, nurses, midwives, clinical officers, as doctors, as those lawfully permitted to provide abortion within the framework of the Constitution. Again, the Ministry of Health standards and guidelines on provision of abortion care were never in challenge and have not been challenged, and so they remain valid. What this decision has done is to then entrench what you'd call a chilling effect, create a possible fear for those who do not clearly understand what happened, to then now expand what the Court of Appeal said to apply it to everyone. The decision of the Court of Appeal affects the young girl and the provider. And the Court of Appeal has, in our view, failed to address the real issues that were determined by the High Court that should have been subject to a challenge before the Court of Appeal, and decided to go outside what it should have handled and reached a conclusion that we do not agree with, because if the High Court has found fault with a process and declared rights have been violated and because of that quashed the trial, the Court of Appeal should have addressed whether the High Court was right on that or not. But the Court of Appeal avoided that entire conversation and only directed its efforts towards nullifying the decision to the extent that it quashed the hearing before the lower court.
Thank you so much, Martin. So I would like to turn to Ruth, because it's very, very clear from your explanation of the case that this court decision is especially affecting women and girls in marginalized communities. So Ruth, or Mumbi, I'm turning to you that how this inconsistently applied abortion law and court decision affect the lives and lives of women and girls and access to care in practice, especially those who are most affected. And what does this case reveal about the human impact of criminalization, forceful application of the law, misunderstanding about abortion, post-abortion care, how it creates stigma and fear, and as Martin provided, focusing on the communities. Over to you, Mumbi.
Thank you so much, Kismodi, and to Martin for the elaborative analysis. And for me, I'll be talking as a human rights defender and a first respondent who works closely with women and girls who have survived sexual violence. And I would love to say that what currently we are witnessing on the ground is that legal ambiguity does not stay inside courtrooms. And what it does, it travels directly into communities and homes and into the bodies of women and girls, and especially poor women and those living in the informal settlement and urban rural communities. And among young girls, what we are afraid what we are going to see through this ruling, it's fear and confusion. And it has also created, confusion around abortion laws that we are afraid as community organizers, human rights defenders on the front line, that it is going to create a very dangerous delays in seeking care for women and girls and even survivors of sexual violence who will be going to hospitals to seek care. And for me, having been working closely with women who already experience multiple forms of structural violence, poverty, displacement, gender-based violence, criminalization, and as well as exclusion from public health systems. I'd like to say that when the law becomes unclear and when it becomes punitive, it affects poor women and working class women who are more vulnerable even more. And in this Malindi ruling, what it is doing, it has really sent a chilling message, especially because this was a case that was fundamentally a post-abortion care case that was involving emergency healthcare, as Martin mentioned. And for me, many women in the communities that I represent, that is the informal settlement, continue to experience miscarriages, pregnancy complications, or sometimes even incomplete abortion. And such women now may fear going to hospital because they will be worried that they could be targeted, they could be interrogated, they could be reported to police, they could face trumped up charges, arrested, because we have dealt with cases where young girls have been humiliated for seeking care. And that's what going to this ruling we are afraid it might have that triple effect on women and girls in the poor communities. And for me, I'd like to mention that it is important that we remember that criminalization does not stop abortion, because I've seen it. It doesn't stop abortion. What it does, it pushes women and girls into secrecy and into unsafe conditions, because into fear and preventable deaths that could have been prevented. It cost the lives of many women and girls. And it's also important to say that those with economic privilege may still access safe care quietly, vis-a-vis poor women who are living in the informal settlement. And also women who are marginalized are going to carry the heaviest burden. And we have seen that. And for me, I'm talking as a person and as a woman who have accompanied many families who have lost daughters, who have lost sisters and mothers because of unsafe abortion and delayed, access to care. I'm talking as a person who has organized, dignified burials, stood with grieving families, and even helped support children who have been left behind by their mothers who died due to unsafe abortion. And for me, what has been powerful, I can say, it's seeing how care can transform community perceptions. When communities witness humanities and when community witness humanity of these women, when they see orphan children, when they see grieving families, interrupted futures, then the conversation, we have seen conversation shift from judgment to compassion and accountability. The majority of poor and adolescent girls and working class women and survivors of violence and the single mothers who already face structural inequalities are the ones who are going to be affected by this ruling. So for us, this is why as movement, as communities, this is why reproductive justice must not be understood only as a legal issue, but a question of inequality, a question of class, a question of patriarchy, and a question of state power trying to police women bodies. It is
Thank
not
you.
about morality. It's about survival. It's about dignity, and it's about healthcare. And whether women, poor women are allowed to live. We are demanding a space. We are demanding a voice. We are demanding laws and policies that are going to impact positively on women, because when you continue criminalizing a care through legislation, through policies that are going to criminalize women, for me, I think the burden goes directly to poor women, to vulnerable communities, because abortion in this country continues to be a struggle. It's a class issue. So that's why we say that a court are supposed to litigate, are supposed to give justice, and are supposed to speak on behalf of the vulnerable people who don't have a voice. So they need to stand in between to protect the voice of the most vulnerable. But what you have seen with the Park case, it's a case of where the courts have decided to sacrifice the lives of many women and girls from the poor communities and the rural Kenya. Thank you.
Thank you so much. I come back to you, Mumbi, what can be done in relation to that. But before we are going to that, I would like to turn to Nelly. And Nelly, you work and your organization is working very closely with healthcare providers and SRHR advocates. And as we heard, it's also impacted the provision of care directly, this decision. So how this ruling affects service provision, including the challenges that the provider face in providing services. And also, can you elaborate a little bit how this court decision very wrongly is a slippage between abortion and post-abortion care that is not even justified in, as I understand, in the law and as Martin provided. So it has a multiple layers of wrong, seems to be a wrong judgment, both on the public health, the legal, and the human rights ground. Can you elaborate a little bit from a service provider perspective?
Thank you so much. And I want to appreciate my colleagues, Martin and Mumbi, for really laying the ground from a legal perspective and also from the beneficiary perspective. And then I come in as the person that wakes up every day to provide the services. Healthcare providers in Kenya, it's been a struggle for years, just fighting to make sure that they wake up every day to provide the services. They've taken the oath to do that. And more so because they were part of the committee of experts that really, worked so hard to ensure that we enjoy Article 26.4, that then gives the power to trained nurses, midwives, doctors, clinical officers to provide abortion care, and more importantly, post-abortion care, which is considered an emergency in this country. And it is definitely non-negotiable. Kenyan government, through the Ministry of Health, has put it in place to ensure that these services are provided. So when this ruling was made, of course, the first thing that then happens with the healthcare providers is, do we continue providing these services? Is post-abortion care now, has become illegal in this country? And automatically that instills fear in the healthcare providers. But you can imagine the community surrounding them, because some of these providers have been arrested for years and have, through our partnership with the center and the community, we've gone to court and they've been acquitted. So remember that, Kismodi, the community know that they provide abortion services. So when such rulings are made, it does not only instill fear, but it takes us back to the stigma, where then the community start looking at the healthcare providers as murderers, as people that are providing services that are illegal in the country. And beyond that, then the fear of, do we wake up to provide these services, but also there is an emboldened anti-rights group that takes advantage of this ruling. And what do they start doing? They start policing. They start, surveilling, carrying surveillance on who are these providers that are providing these services. And of course, working very closely with the law enforcers to make sure that they're not only intimidated, harassed, but they are arrested. And these are, from where we sit right now, that is all that is happening within the community that we sit in.
Nelly, can I ask just quickly that do you see that it's happening more intensely since the judgment? This criminal behavior from like the criminalization is happening more intensely since the court decision?
For sure, the anti-rights have taken advantage of the ruling. They are spreading disinformation on social media and being very categorical in causing fear, not only to the healthcare providers, but also to the community, the women and girls that need that. So right top on the list, the thing we are dealing with is disinformation. And so quickly, what we are doing together with our partner, the Center for Reproductive Rights, is we are sensitizing our providers on what is the correct standing of this ruling. And beyond that, because we know they are predisposed to harassment, and we've seen this in the previous years, we are also conducting a safety and security training on our providers. And this is generally to make sure that their safety comes first. What are they doing in the facilities to ensure that they are taking the history of the patients that come in well? They're not just rushing to provide care, but they're making sure that if a client is walking in to access care, they're taking the history, providing all the relevant information that is provided, and making sure that this case then qualifies to access safe abortion care. Beyond that, we are also saying that be very careful who you give information. So where we had made advance in providing abortion through telemedicine, we are not able to do that because you just don't know who is calling on the other side. So really help making sure that our providers are very keen on who are they talking to via phone, and when, if necessary, ask them to come to the service, to come to the healthcare facilities. Consent, we are saying make sure any client that is in need of these services, please make sure they consent. Make sure they provide the consent. And this just takes us several years back where, the environment was quite restrictive. It was quite hard for even a girl or a woman to provide services. But we are doing this to mitigate and also protect the healthcare providers. Then the issue around, where we would get some of these commodities even at the pharmacy. Remember the pharmacy, Kenya, through the task shifting policy, pharmacies had been allowed to dispense some of these pills. It can't continue anymore because then what are the legal implications of that? So these are some of the things that are really happening and just creating that environment that is not conducive for, to continue providing these services. Remember, post-abortion care, like I said, it's an emergency care recognized in the Constitution, and also, as Martin had shared, it is a reproductive health right. And it has, over the years, helped in reducing maternal mortalities and morbidities. Remember, we are talking of an emergency. We are talking of a woman that is coming to a facility and an abortion has been started somewhere else. So as they walk to a facility, they're either bleeding. Some of them even have, the products of conception hanging. So it is a case of them coming in and a provider quickly taking them to the emergency room to provide care. And when a ruling is made and saying that it was illegal for the provider to do that, then that means that how many women are we going to predisposed to morbidities and mortalities because of cases or services that are considered to be life-saving? Then, of course, the issue of giving women the agency. Remember, like Mumbi said, we've done a lot of work, on working around social norms, but also importantly, letting women know that they have the power to make decisions over their lives. And this is because of a lot of social cultural context.
So I'm coming back to you, Martin, and just briefly, can you please explain that from a legal point of view, what legal pathways are available for appealing this case? What are the next step to protecting reproductive rights in Kenya? What kind of legal mechanisms, and what are you planning to do as a movement?
Thank you so much. And thanks to Mumbi and Nelly for giving the other perspective. Courts are to give effect to fundamental rights and freedoms, to give dignity, to protect humanity, safety, and just the well-being of the community. If people fail to get that from courts, then courts are missing to bridge, to do what exactly they are meant to do. And in this case, as has already been explained, the Court of Appeal has created more doubt around the law rather than an assurance and clarity. And bearing in mind that public health sector does not progressively provide safe abortion services. And that is why the attack is on safe abortion. And nobody wants to directly affirm post-abortion care as emergency care and care that you should not touch. And therefore, in these circumstances, because the decision involves interpretation and application of the Constitution that already provides circumstances when abortion is lawful, we are directly moving to the Supreme Court. We want the Supreme Court to, one, reinstate protection, integrity, and certainty to those who are seeking care within the Constitution and existing laws of the land. I reiterate that the Constitution of Kenya was never changed by the Court of Appeal. The existing laws were never changed by the Court of Appeal. But what that decision communicates totally destroys the stable fabric of access to reproductive health care in the country. And it is the Supreme Court that must then intervene.
So, but I understand just briefly before moving to Mumbi that it will take years, right? By the time the Supreme Court may make a judgment on this, or how long this procedure may take.
We actually envisage that if we directly go to the Supreme Court, in 2 years we would have got a decision. The Supreme Court now renders its decision in about 2 to 2.5 years. So we are not looking at more than 3 years before we get the Supreme Court decision. And just remember that we are not asking the Supreme Court to change the law. We are just asking the Supreme Court annul this bad decision from the Court of Appeal that is creating uncertainty where other courts have created certainty, where providers have now established and are offering care within the law, where women had already attained certainty and confidence in the healthcare system that they can get care when they qualify and they can get it from qualified professionals.
So while these 2-3 years may consider to be a relatively quick process, the damage already has been done. So, Mumbi, what communities, feminist movements, and advocates can do to mitigate the stigma, misinformation, anti-rights narratives that both on abortion and post-abortion care that this judgment create?
Thank you, Kismodi. Let me respond by saying that the most important thing that a feminist movement must continue doing is reclaiming the narrative around the reproductive health from fear, from shame, from misinformation and disinformation that the anti-rights are capitalizing on. Anti-rights movement, what we have seen that they thrive in when silence and stigma and moral panic dominate public conversations. So our responsibility as feminist movement, community organizers, is to center truth and lived realities and experiences of women and girls who continue to suffer from all these shenanigans from the anti-rights. And we must continue building on political education so people understand that post-abortion care is essential health care like any other care, and that reproductive justice is connected to broader struggles from climate justice to housing rights and to other freedom from violence. And we must continue amplifying the voices of women who are directly affected, and not to speak about them only as statistics, but not to speak to them as a statistic or legal subject, but as human beings with dreams, families, and dignity. Thank you.
Thank you, Mumbi. So, Nelly, and what can happen in terms of health system policy? Is the government, the Ministry of Health, has accountability here not to obstruct or stop the obstruction of provision of legal services? What can you do from the health system point of view?
So number one, what government needs to do is we cannot continue talking about abortion and post-abortion care in isolation. We need to integrate abortion, post-abortion care with family planning and comprehensive sexual reproductive maternal health into the larger primary health care. That way, when we are talking about, strengthening the system to ensure that it's responsive to the needs of women, then it is fully within the health system. Then number two, government has to quickly ensure that healthcare providers are well-trained, capacitated, right from the private sector to the government sector, to the public sector. And this even includes training of healthcare providers before they leave their training institutions, the training school, preschool, pre-training institutions. And this is to also ensure that by the time they are qualifying and starting to be professionals, they already have the knowledge in terms of how to ensure they provide comprehensive sexual reproductive health, maternal health as a package. Then in terms of supply and commodity, because we cannot talk about quality care, system strengthening without ensuring timely supply of quality commodities and supplies, then government has to ensure that this is part of the essential medicine. I know in Kenya, part of the abortion pills are part of the essential list. However, we have to make sure that they are just not in a document, but these commodities are available right from the big facilities to the community facilities that serve the vulnerable women and girls. Then finally, within the government system, they must make sure that where, because of anti-rights movement, because of disinformation in the community and healthcare providers are arrested, government has to ensure that they have legal officers that then step in quickly to protect women, healthcare providers as it is mandated in the constitution that we have, because it's the government responsibility to ensure that healthcare providers are complying with the oath that they took, but also ensure that no one is intimidating and harassing the healthcare providers. I think if we looked at all that, then we have a system that is responsive, functional, and it's able to protect the women and girls in our country.
Thank you so much. I really appreciate, and I think the three of you were very, very clear that how this court decision is kind of representing what is happening globally and what is the movement of the anti-rights movement is creating in terms of misinterpretation and misuse of information. What is about the future of sexual and reproductive justice, bodily autonomy, rights-based healthcare, and the rights and justice of the most marginalized communities around the world? I really, really appreciate that you have been here today, and looking forward, I think the whole global sexual and reproductive health and rights community to support the case, and looking forward to hear from you again about the progress of the case. Thank you so much for your time and for your very hard work and on this, and congratulations for the great work you are doing. Thank you so much.
Thanks so much.
Thanks for joining us for this insightful conversation. Please check the show notes for a link to the SRHM journal, which is available online and open access. Follow us on social media and sign up for our newsletter to receive notifications for new publications. If you're enjoying this podcast, please subscribe, give us a rating, or leave a review. Sharing evidence-based and rights-grounded knowledge is our passion, and it's also critical to support the advocacy and actions that need to be taken to improve SRHR for all. We would very much appreciate it. Thank you for supporting the SRHM podcast, which is produced by our staff. The music was composed by Tiber Christian and Salomon Beautond.